Case put forward to you today is that of Miss Gemma J. Taylor vs. Conduct and Competence Committee following allegations of misconduct exhibited on the 12th of July 2018 by Miss Taylor whilst on duty as a paramedic for the East of England Ambulance Service NHS Trust. As such, whilst attending to an elderly patient at their property, Miss Taylor allegedly took and consumed the patient's oral medication of codeine without consent as witnessed by her colleague DG. Reasons established for such actions were due to Miss Taylor suffering from a severe toothache, which had not been relieved by earlier administration of her personal paracetamol and ibuprofen. Although Miss Taylor admitted to ingesting the medication and reported the incident to the HCPC on the 21st of July 2018, she still maintained her innocence in regards to taking the medication without consent due to having secured permission from the patient prior to taking the medication. Contrary to this, witnesses, who were Miss Taylor's colleagues, remain clear that the medication was taken without consent. Through further investigation, Miss Taylor's account of the events was found to be inconsistent and dishonest. It was proven that Miss Taylor took patient one's codeine tablets for her own personal use without their consent whilst attending to them. Therefore, the HCPC panel deemed this to be a breach in misconduct, and by reason of the misconduct, Miss Taylor's fitness practice was impaired. As such, her registration was suspended for 9 months. It's important to note that these allegations are in line with regulations and policies set in place in the UK. However, if Miss Taylor was a Queensland-based paramedic, the legal issues surrounding the case slightly differ. The primary concern in this case would be theft, constituted under the Criminal Code Act 1899, sections 390 and 391. These state definition of stealing to be that of a person who fraudulently takes anything capable of being stolen, or fraudulently converts to the person's own use or to the use of any other person anything capable of being stolen, is said to steal that thing. In Queensland, codeine was initially listed under Schedule 2 of the Drugs Misuse Regulation 1987. However, in December 2016, a notice under subsections 42 ZCZS of the Therapeutic Goods Regulations 1990, the Australian Therapeutic Goods Administration rescheduled codeine to be classified as a Schedule 4 drug. As stated on the Federal Register for Legislation under the Poisons Standard, June 2021, the definition of a Schedule 4 drug is as follows. Schedule 4, prescription-only medicine or prescription animal remedy substances, the use or supply of which should be by or on the order of persons permitted by state or territory legislation to prescribe and should be available from a pharmacist on prescription. The Health, Drugs and Poisons Regulation 1996, Annex 9, page 291 also states that codeine on its own is classified as a restricted drug of dependency, Schedule 8, and therefore possession without authority is illegal. As Ms. Taylor took the Schedule 4 and 8 drug, the question remains about the outcome of this case in regards to Queensland policies and legislation. The potential outcome is as set out in the Health Ombudsman vs. John Christopher Reek, 2017, QCAT 173, following a similar breach in professional misconduct. Similarly, a nurse had stolen a Schedule 8 drug, fentanyl, from their workplace for personal use. Australian Health Practitioner Regulation Agency, or APRA, referred this case to the Health Ombudsman, who referred the matter to the Queensland Civil and Administrative Tribunal, QCAT. This resulted in a conviction of stealing as a servant, and a 12-month probation order was made with no conviction recorded. So APRA works in a partnership with 15 national wards to ensure the community has access to a safe health workforce across all professions registered under the National Registration and Accreditation Scheme. There's various functions such as professional standards, registration, complaints, compliance, accreditation. It has an influential voice regarding fitness to practice hearings and outcomes of professional misconduct. In Ms. Taylor's case, her misconduct would be notified to APRA, and this registering body would refer the case to the appropriate source if necessary for further investigation. APRA also provides policy advice to the national boards about registration standards, codes and guidelines for health practitioners. As such, the Health Practitioner Regulation Law Act 2009 and the Health Practitioner Regulation National Law and Other Legislation Amendment Act 2017 and the Ambulance Service Act 1991 are Queensland's legislative acts used to convict health professionals of failures to comply with Code of Conducts. Part 13, Division 1 of the Health Practitioner Regulation Law Act 2009 defines and details the Act's relevance in relation to registered paramedics and utilising the Paramedicine Board of Australia states that professional capabilities for registered paramedics first domain states that in order to maintain professional and ethical conduct, paramedics are required to follow relevant state and territory legislation and regulations. Furthermore, Queensland Ambulance Services Clinical Practice Guidelines for Clinician Safety states that Queensland paramedics are required to meet the physical and psychological demands of work to ensure adequate clinician vigilance, situational awareness, and professional performance. In Ms. Taylor's case, this requirement was not met due to the severe toothache she was experiencing, interfering with her professional judgment and performance. The Paramedicine Board of Australia's Code of Conduct for Registered Health Practitioners discloses that if a paramedic knows or suspects a health condition which could adversely affect their judgment or performance, they are required to seek expert independent objective advice or healthcare. This healthcare does not refer to taking a patient's medication without their consent whilst attending to them. So how does this contribute to patient safety? Well, the role in patient safety is widely diverse, but the implementation of registering bodies such as APHRA and fitness to practice hearings allow for a safety net for all patients and health professionals alike. Take Ms. Taylor's case, for example. It's evident that Ms. Taylor breached several laws which place both her fitness to work and patient care relationship at risk. As such, her misconduct would be referred to APRA for further investigation. This process and the nature of this fitness to practice hearings are put in place not just to protect patients but also professional titles as well, as they verify that strict health professional standards are being adhered to. In conclusion, our registrant, newly qualified paramedic Ms. Gemma J. Taylor, following her fitness to practice hearing, was sentenced with a suspension to practice for the duration of 9 months. Whilst the breach in professional conduct included dishonesty and theft, the warrant for the full strike-off was not granted. The suspension was determined appropriate due to the nature of the hearing, and therefore served as an opportunity for Ms. Taylor to reflect and remedy the misconduct whilst maintaining patient safety.